everybody, offline as well as online participants. Uh, we'll be starting today uh, with two very important topics. One on non-profit organizations, which have major changes, and one is on appeals and dispute resolution. So, sir is here, and over to you, sir.
Good evening, everybody. It's a pleasure to be here amongst all you learned tax peoples on the dais and of the dais. It's a matter of joy with Vivek being by my side. I am sharing this conference with confidence because you will correct me very well. No. I go wrong.
You cannot be.
Now you see the most important chapter which concerns the new Act 2025 is chapter 17B of the Income Tax Act 2025. It is a special provision for registered non-profit organization, which is section 332 to 355 of the new Act. Now for the first time, this chapter is headed a special provision for registered non-profit organization. There were no such chapter under 1961 Act or under 1922 Act. These were all scattered provisions. Under 1961 Act, provisions of the NPO were scattered across multiple sections. Section 215, which is charitable purpose, has been redefined. I shall come to that later. Section 1023C, which provided exemptions to the various educational and medical institutions. Section 11 and 12, which provided the assessment and compliances of the voluntary contributions received by the NGOs, and section 12A, 12AA, 12AB all pertain to the registration and procedures. Section 13 outlined the disqualifications for getting benefit under section 11 and 12, and they have now been streamlined and consolidated under part B of chapter 17, that is section 332 to 355 of 2025 Act. The expression trust or institution or university or hospital or religious trust are substituted by the single expression non-profit organization. Earlier, as I told you, there were no such chapter and there will be no such categorization. The Income Tax Act 2025 marks a significant shift in legislative architecture by reorganizing and consolidating the tax framework applicable to non-profit organization. While the foundational policy of encouraging genuine charitable activity remains intact, the new Act replaces a fragmented, exemption-driven regime with a structured, compliance-oriented code featuring clearer statutory definition, consolidated provisions, and codified consequences for non-compliance. This session examines the key changes in the special provision governing registered NPO under the Income Tax Act 2025 vis-a-vis the Income Tax Act 1961, highlighting both substantive reform and area of deliberate continuity. Now, first of all, most important section is the definition of charitable purpose under the old Act 2 subsection 15 and new Act 2 subsection 23. Now, the 7 areas which have been grafted a charitable purpose are relief to the poor, education, yoga, medical relief, preservation of environment including watershed, forest and wildlife, preservation of monuments or places or object of artistic or historic interest, and advancement of any other object of general public utility. Now, there is a restrictive provisions earlier contained in section 2 subsection 15, which has been omitted now. This proviso, which was a hinder to an organization like us, that proviso was hitting us most, that proviso is now gone. So therefore, it is a welcome change as far as the definition of charitable purpose is concerned, vis-a-vis the provision in section 2 subsection 15 under the 1961 Act. The omission of restrictive provision, so therefore is positively something which has to be cherished. It is cherished because this has been right from 55 ITR, Andhra Chamber of Commerce, you will remember, to the Indian Chamber of Commerce, 101 ITR, Justice Krishna Iyer's judgment, then Surat Art Silk, then all other judgments, and later on the latest, that Gujarat judgment, which held clearly that any surplus being generated, unless it is very mean, will go out of the definition of charitable purpose. So, all those judgments are not tell you that it has become obsolete, because when Indian Chamber judgment or Andhra Chamber of Commerce judgment came, at that time that provisos were not there through section 2 subsection 15, and likewise in the Surat Art Silk also it was not there, but Surat Art Silk now will have a stronger basis to be followed rather than the other judgments which has come. Now, the broad changes in the legislative architecture. Now, placement of NPO provisions. It was scattered earlier under across 215, 1023C, 11 to 13, 12A, 12AB, 12AC, 12AD, ATG, 115BBC, 115BBI and 115TD, TF. It is now consolidated in chapter 17B, section 332 to 355. So, in this chapter clearly brings out everything relating to the non-profit organization. So, the easier navigation and reduced cross-referencing. Now, the drafting style, amendment driven proviso, it was heavy because provisos and explanations used to play a major role, and but now this modular table based cleaner drafting. This table based drafting gives you a very clear picture, that leaves no confusion at all. So, therefore, it is welcome that this table based cleaner drafting has been done. So, lower interpretational friction. So, there is not much scope to differ with this drafting, because there is not much to interpret in that. The language is very simple and carves out the point by point rebuttal of the things which they do not want. Now, the policy intent, exemption based charity regime, earlier same intent with compliance monitoring and no dilution of the charitable status. Now, let us come part by part as to what are the components of the NGO registration and functioning of the non-profit organization. The first part is registration, because registration, unless it is registered as an NGO, this cannot function within the framework of the Income Tax Act enjoying tax exemption. So, there a part 1 is chapter 17B 332 to 333 deals specifically with the registration framework for non-profit organization. It replaces the multiple legacy entry points and approvals with a single time-bound registration mechanism covering provisional, fresh and renewal registration administered through a fully digital process. The emphasis shifts from one-time approval to periodic review. It makes registration the central compliance gateway for exemption and donor linked benefits. Now, you will find there is a table. This table will demonstrate that a NGO when formed and has not started functioning, then how they have to apply, and what will the period of the initial approval which shall be granted to them for 3 years, how thereafter when they start functioning, then they have to apply within the time frame, and within the time frame then the registration is granted. That registration will be there for 5 years. Likewise, the table will demonstrate as to how the registration will function, how renewal will be done. Now come to section 332, definition of person for claiming benefit is registered non-profit organization is given. Earlier you see this definition of person was not available in the act. Now this 332 defines person. What are those persons who are eligible for making an application under the section for registration? These are a public trust, a society registered under the Societies Registration Act 1860 or under any law in force in India, or a company registered under section 8 of the Companies Act 2013, or the company registered under section 21 Company Act 1956 and deemed to have been registered in pursuance to section 465 2G of the Companies Act 2013, or a university established by law or any other educational institution affiliated thereto or recognized by the government, or an institution financed wholly or in part by the government or a local authority, or any person referred to in schedule 3 table serial number 27, table serial number 29, table serial number 36, and in schedule table serial number schedule 7 serial number 10, table serial number 19, and table SI serial number 42. Now, if you go to these tables are the exempt income table. In that exempt income table, these serials are mentioned. These serials requires registration. Otherwise, these entities will not enjoy exemption. So, therefore, any other person notified the board in this behalf. So, only these persons, unless notified by the board, is eligible for application for registration under the act. Now come the registration procedure. Registration architecture, 3-tier system. Earlier 12A initial, 12A permanent, 12AB revalidation and renewal. These were the 3 sections earlier. Now unified registration system under section 332 for provisional, fresh and renewal. So this is contained in 332. That this simplifies the entry compliance and remove artificial qualifications and layers. Application process, online filing introduced later, multiple forms and timelines. Now fully online, system driven application for all categories. So you can make application only online. So it will never be lost. You remember why Bengal Chamber of Commerce could not be registered formally by the Commissioner of Income Tax? Because there was a physical filing, and that physical filing where our application was lost, nobody knows. So no proper approval was granted, which has led to litigation from 1973 onward till 2025. So 52 years, can you imagine? So these will be now eliminated. So digital first design from inception. Time limit for approval, provisional 1 month, regular fresh up to 6 months. That was in 19 same has been kept. So substantive continuity, procedural clarity retained. Authority earlier PCI and CIT, now again PCIT, CIT, no change in jurisdiction. Power of inquiry and condition, PCIT, CIT empowered to seek information and condone delay, same powers retained, so no dilution in the power. Validity of registration, 12A indefinite validity, 12AB 5 years. Time bound validity mandatory, fresh, renewal 5 years, provisional 3 years. Introduces periodic review and continuous compliance culture. So if it 5 years, then it is a periodic review. In the meantime, if anything comes to the notice of the commissioner that you have not followed the procedure or you have violated the provision, then cancellation power also has been retained, as come to later. Renewal requirement, required only after introduction of section 12AB. Now mandatory renewal cycle built into the statute. So prevents once approved forever exempt situation. Auto renewal mechanism, not expressly structured, system driven renewal process subject to the compliance, reduces administrative friction. Change in objects, fresh registration required, objects materially altered, re-application required on deviation or non-compliance, explicit linkage between object and the exemption. Monitoring of activities largely post facto through assessments, embedded compliance review through renewal cycle, shifts from reactive to preventive oversight. So, all these compliances review will be taken up for consideration in the renewal cycle of choice of tax regime. No explicitly statutory switch concept. Section 333 allows one-time choice between new regime, 85% application based exemption or old provisions. Introduces regime certainty but restricts frequent switching. Then frequency of switching not applicable, only once permitted, prevents tax arbitrage. Tax impact on switching not codified, accrued interest may become taxable on switch, ensures neutrality and prevents deferral abuse. Approval for donor deduction, separate approval under section 80G and 1023C, now single harmonized approval under section 354. Major compliance simplification for NPO and donors. Donors facing compliance, fragmented certificates and reporting, now unified reporting and certification framework, improves transparency and donor confidence. So, these are the registration framework laid down in the new law. So, you will see it is all a streamlined procedure. Now, come to the part 2, income of registered NPO, section 334 to 343, part 2 of the chapter 17B of ITA 2025 converts a concept driven exemption regime into a clearly codified tax computation model for NPOs. It significantly improves a structure, predictability and compliance discipline without causing any change in rates or policy. Now, if you have this chart with you in respect of any thing you want to know about the 2025 Act NGO, this will give you the complete idea about it. So, therefore, you must retain this chart. I have done it with lots of hard work. So, this charging framework for NPO income, no single charging section, taxation scattered across section 11, 12, 13, 115 BBIE, 115 BBC and 164(2). These are the charging provision in the 1961 Act. Now, section 334, explicit charging section for registered NPOs. First time a clear tax computation framework for NPO. So, it is a good, very remarkable change and very dynamic indeed. Overall tax rates, 30% on certain income like anonymous donation violations, exemption based otherwise. Now, 30% on a specified income. All these incomes have been categorized as specified income, normal rate on taxable regular income, clarity and certainty policy unchanged. Concept of regular income not defined, inferred from section 11.1, 11.4, 11.4a and 12. Now, under the new law, section 335 formally defines regular income. Major structural reform. Components of regular income addressed indirectly under various provisions such as 11.1, 11.4, 11.4a and 12.1. Now, under the new law includes activity income, house property, investments, voluntary contribution, incidental business. So, the transparent classification has been made. Activity income definition not expressly defined, now defined as receipt from registered charitable and religious activities. New concept, interpretational issues may arise. Taxable regular income, section 11.1a b, 85% application rule, section 336 same 85% application rule retained. So, no substantive continuity. Shortfall in application, deemed application allowed via explanation, deemed application allowed, 5 years utilization window, greater structure, time bound flexibility. Tax rate on shortfall, text at MMR 30% in violation cases, same 30% on shortfall, rate certainty. A specified income concept, covered via multiple sections 115 BBI, 115 BBC, 164(2), 13 and 12(2). Now section 337 consolidate a specified income, major consolidation. Income are of the same nature, but they have been consolidated in this section.
Sir, here,
Yes.
I'll just take 1 minute. Now, sir, if you go through section 337, specified income, this clause 4, it
Any investment or deposit made in contravention to the provisions of section 350 out of any income, accumulated income, deemed accumulation income and corpus deemed corpus or any other fund. So, income now, this income is not conforming to the requirement of the prescribed investment. This income will be taxed at the rate of 30%.
now, sir, my point is, they have not said income out of the investment. They have specified the income
No,
as the investment itself.
No, a specified income. A specified income means any investment or deposit made in contravention to the provision of section 350 out of any income, accumulated income, deemed accumulated income, corpus and deemed corpus or any other fund. Now, the tax will be not be charged on this investment, but the resultant income therefrom.
Yes, sir. So, that is the thing. This is, in my view, this is not coming out. Because-
you are right, because they are not
says
saying
income from
they are
investment.
not saying the income arising out of it, but in this you see, although under the NGO the concept of taxing an income is not like business income under section 28 to section 43. Now under the new provisions it has been categorized, but it is the application of income or either in revenue expenses or in the capital expenditures. Now these investments which are prescribed for the purpose of availing the benefit of the exemption needs to be invested in the prescribed investments as per the statutory requirement. The moment you cease to do that, you make a violation.
Yes.
If you make a violation, then this violation to my mind cannot automatically become income, because in order to it become income, you have to do something more than mere making an investment. So to my mind, since these are income generating investments, the income generating out of it will be taxed at the rate of 30% and not the investment per se. This is to my legal mind, I can say. We can make little more investigation in this regard to ultimately come to a conclusion on the final view to be taken in the matter.
Right, sir. Because if this happens, it will be
It
a
shall be
major
very-
problem.
Although no charitable trust does it now.
Sir, many many charitable trusts now, because they say that okay, why invest in mutual fund? We'll pay tax on the invest income. That is the only thing. My registration
No,
is not cancelled.
see, if your registration is cancelled, then because you are deliberately indulging into an act which is not authorized by law, then you will incur the liability of being taxed on the entire corpus at the fair market value because of the cancellation.
Okay.
So that will be a different situation altogether. By default, basically such investments which are made, which are not conforming to the prescribed mode, is because of the confusion. Sometime you make the investment, you are expecting a notification, it does not come. So there you may have violated, and you may have not deliberately kept it beyond a point you are bound to keep. And the moment you got that leverage, you immediately shifted the investment in the proper investment. Your bona fide you must be make clear. Because so I am saying this making this a statement in the case of bona fide charitable trust. I am not making a statement in respect of a deliberate violation which is being done, which is not permitted by law. So, to my mind, in a situation where you have not adhered to the investment pattern defined in the Act, and due to some confusion or due to a lack of understanding or due to wrong advice, and then the income resulting therefrom will be taxed at the rate of 30% without conforming to its application part, resulting into the application of income and allowing of deduction. This is my understanding. You,
Okay.
Note down, Ananya will research on it.
Sir, Aditya ji, you had some. Ekta mic.
11.5.
Aditya ji, take the
आप
mic,
ले लीजिए,
please.
माइक ले लीजिए.
You can invest in certain mutual funds, certain government shares.
Yes, they are notification based.
Yeah, so still it continues in the new section also.
Yes, because the new rules have not come,
Ah.
and therefore, as far as this act is concerned, this will become effective from 1st of April 2026. By that time, notification will come. As far as new act, old act is concerned, it is still continuing. So, you are eligible for that. So, unless and since these are the eligible investments permitted by those notifications will still hold good till they are rescinded. So, therefore, to my mind, though such investment will come within the framework of the permitted investment under the new law also.
Right.
Yeah, they are very reasonable questions, and all of you whosoever has any doubt, you must ask, because I also am learning. So, when your question comes, I also think as to how to answer on those points, and do I need to make more research before coming out fully on the subject. Now, a specified investment, as I told you, we have discussed. Anonymous donors, fully taxable. Now, taxable beyond 5% of the total donation or 1 lakh, which is higher. Now, these small trusts have been given these benefits. There are mandirs where small donations in cash come. So, this liberalization has taken place. Other specified income categories, a spread across law, now it is 11 deeming situation listed in section 337. 11 deeming situations listed in section 337. So, predictability and reduced litigation. Misapplied capital private benefit, section 13 consequences. Now, section 337 explicitly covered in the section as to what is violation and what is the consequence. So, clear enforcement provision. Income not part of regular income, 11(1)(c), 11(1)(d). If an interested person is using it, then now section 338, no substantive change. Foreign application of income allowed with CBDT approval, international welfare, section 338A retains same bifurcation, continuity. Corpus donation, 11(1)(d), now section 338B, no change.
Sir, here,
Yeah.
just I'll again take 1 minute.
Yes.
In fact, when I was in your office, I learned from you only. Sir, 338A2 now, earlier, I will show you the earlier section. Earlier, I mean currently, they say for that for non-profit organizations, the following income shall not be included. Income applied outside India, part now 2, it states created on or after for any NPO
April
after 1st April 1952 for charitable purposes where such application of income
outside
India tends to promote international welfare. It has restricted here, but it does not give a application with overriding instructions. Earlier, I remember, sir.
No, there are two things. There is subclause A, 1 and 2.
Yes, sir.
One is the trust or the funds which have been created prior to 1952.
Yes.
There, if the CBDT approves, then you can go ahead and do that charitable and religious purpose. In regard to the second, it has to have a overriding provision that India tends to promote international welfare in which India is interested. Now, India's interest is that in Uganda, you promote a particular welfare scheme, and you do that because India's yoga, say yoga, is a charitable activity.
Right.
Now, because of India's intervention, the UNO has recognized it. Now, all the countries are promoting it. For that, the government of India gives you a permission that you engage yoga teachers, send them to the various countries to promote yoga. Now, this is done with the object that India is interested. This welfare of the human being through the promotion of yoga, India is interested because we are advancing the Indian philosophy, Indian culture and helping India's image abroad. So, therefore, this is with a rider.
Yeah, sir, but there was another rider in the earlier Act 11C1. It said, to the extent to which such income is applied to such purposes outside India.
Yes.
So it was a application with a overriding direction that has been removed. So
No, it has not been removed. On the contrary, it is inbuilt. Again, you read this section. Created on or after 1st April 1952 for charitable purposes. Charitable purpose has not been divorced.
yeah, that is
Purposes where such application of income outside India tends to promote international welfare in which India is interested. So, where is leeway? Do they say that you can misappropriate or you can to that extent? First of all, you will be granted the permission. In that, maybe there will be a limitation. That you can spend so much, you can go to such and such country, you can engage so many teachers. So, these are all based on either the notification to be issued by the CBDT, wherein these classifications and restrictions shall be built, or on the individual application made by the various trust or NGO, then they will, all these restrictions shall be placed on the amount of expenditure, the countries. Somebody says, I want to send to Pakistan. India will not be interested. Somebody says, I want to send to Bangladesh. India may not be interested. Somebody wants to say, I want to Turkey. India may not be interested. So, there will be country based promotion of these schemes in which India is interested. India is interested written there.
yeah, India is interested.
Am I clear?
Right, sir.
So, corpus donation I have cleared. Meaning of corpus donation, you read section 350 where the meaning has been given now,
Yeah.
right. Now, explanation 3A to section deemed corpus for religious purpose. Explanation 3A to section 11.1 Now it is section 340. So it clearly defines what is deemed corpus for religious places. Application of income general rule, multiple explanation to section 11. Now it is in section 341(1). Consolidated drafting. Capital expenditure allowed if for the object, allowed, no change. Depreciation restriction, section 11(6). Now section 341, same anti-double benefit rule, because the whole reason behind it was that since you are allowed the application of the entire capital expenditure, the question of depreciation on that does not arise. Then TDS compliance impact, section 40A read in, section 341 plus section 35B1 codified adjustment mechanism. Now cash and banking mode restriction, section 40A3 logic applied, section 36(4) to subsection 7 integrated with the NPO regime. Accumulation up to 15%, same section 342. Accumulation beyond 15%, 11(2), now section 342 with a cap of 5 years. Then misuse of accumulated income, 11(3) and 13(9), now section 337 and consequences, integrated enforcement. Then deemed accumulated income, no such concept. Now section 343 introduces deemed accumulation 15%, new compliance layer. This is a new compliance layer. So that is a new introduction. Mandatory investment of deemed accumulation, earlier not applicable, now investment in section 350 modes compulsory, tightens the financial discipline. Now come to part 3 of the NGO provisions. Commercial activities by the registered NPO, section 344 to 346. Part 3 of chapter 17B of ITA 2025 does not prohibit genuine charitable operations, but decisively curbs commercial drift by introducing category based restrictions, removing harsh deeming fictions and replacing litigation prone consequences with clear statutory taxation rules. A statutory placement, a spread across section 11(4), 11(4)(a) and proviso to section 215. Earlier beyond 25 lakh commercial activities were charged to tax, now consolidated in section 344 to 346, cleaner structure, easier navigation. Business undertaking held as property, section 11(4), AO may recompute business income, section 344, AO may recompute business income, substantive continuity. Deeming fiction on excess income, excess income deemed applied for non-charitable purposes and taxed, no deeming provision. This is a departure. So major tax friendly change, because we are not in business. Why deem income? How I would apply by deeming income? So treatment of recomputed income, automatic adverse tax consequences, now taxed only as per normal computation rules, reduces rigidity and litigation. Commercial activity general rule, permitted if incidental to object, 11(4)(a). Now categorical restriction introduced, section 345, a structural tightening. So this is how we have come to part 2 हो गया. Now come to next page. पेज 7 कहाँ गया मेरे पास? हाँ. Now to come page 7. This GPU NPO general public utility covered under the proviso to section 215, specifically governed by section 346. GPU rules elevated from definition to operative provision. Commercial receipt threshold, 20% of total receipt, 20% of total receipt threshold retained. separate books for commercial activity, not expressly mandated. Now, mandatory under section 346, compliance clarity. Consequences of breaching 20% limit, loss of charitable character, litigation heavy, excess tax as specified income, predictable tax outcome. So, no cancellation, nothing. Tax character of excess commercial income, unclear, dependent on interpretation, now explicitly taxed as a specified income via section 337, reduces ambiguity. Now, you see, if all these amount has been identified as income chargeable to tax at the rate of 30%, then the institution also knows what tax has to pay, and it does not suffer the cancellation from registration or the heavy burden of being taxed on the entire fund of the trust with the present market value. So, that way it is a great welcome
Yeah,
change
very welcome.
which has been brought about. Now, come to part 4, 347 to 350. Part 4 of the chapter 17B of ITA 2025 does not introduce new compliance burden for NPOs. Instead, it recognizes existing obligation, that is books, audit, reporting and investments into a clearer consequence linked framework. It strengthens transparency without altering the policy substance. Statutory placement, compliance conditions embedded mainly in section 12A and allied rules, now consolidated into section 347 to 350, clearer segregation between substantive exemption rules and compliance machinery. Now, what are those? Maintenance of books of account. Section 12A 1B, books of account, books required if income exceeds basic exemption limit. Under section 347, the new law, same threshold and obligation, no substantive change, clearer drafting. Audit requirement, trigger, if the total income of the registered NPO exceeds the maximum amount not chargeable to income tax in any tax year, the accounts of such NPO must be audited by an accountant. Same audit trigger retained under section 348 to 349, no change in the threshold. The audit report, form 10B, 10BB under section 12A 1B2, same forms continue under section 348 and 349, continuity in reporting from work. Additional reporting, re-registration regime, section 12A1BA introduced reporting obligations, now integrated within section 348 to 349, harmonized into single compliance block. Due date for filing of return, 139(4)A, exemption linked to timely filing. Now, section 263(1)A(3) read with section 348, renumbering substantive rule unchanged. Then linkage between timely return and exemption. Exemption denied if return not filed within the original due date, explicitly retained. Reinforces discipline, no relaxation introduced. Consequences of audit reporting failure, loss of exemption, taxation under section 164/13, taxation triggered under section 352, conscience codified in violation chapter. Modes of investment and deposit, 11(5) with list of permitted modes, section 350 read with schedule 16, schedule based clarity. Actually, great clarity has been brought because of this schedule. Then power to notify additional modes, CBDT, central government via notification. Section 352 expressly empowers notification, greater statutory clarity. Investment compliance relevance, linked to exemption eligibility, linked to exemption accumulation corpus rules, integrated compliance ecosystem. Overall compliance philosophy, condition based, section specific. Now, this under the new law, life cycle based compliance framework, shift towards governance and monitoring. The part 5, violations and consequences, section 351 to 353. Part 5 of chapter 17B, ITA 2025, does not introduce harsher consequences for NPO but reorganizes and systemizes the violation and exit tax regime. It replaces fragmented enforcement with a predictable, formula-driven and procedurally integrated framework. These are a statutory placement. Earlier it was section 12AB, 12AC, 13, 115 TD, 115 TF. It is consolidated now under section 351 to 353. The structural consolidation improves coherence. Concept of a specified violation defined implicitly under section 12AB 4 and 5, now explicitly defined under section 351, clear statutory articulation. Cancellation of registration on a specified default under section 12AB, now cancellation framework retained under section 351, continuity. Trigger events for violation, narrower and section specific, expanded and tabulated triggers, predictable enforcement. Failure to apply and modify object, addressed indirectly, now explicitly trigger for violation, compliance discipline strengthened. Exit tax accredited income concept 115 TD and TF, now section 352, consolidated, cleaner and legislative design. Events triggering exit tax, conversion, merger with dissimilar entity, dissolution and failure, same additional procedural default, broader but clearer coverage. Valuation of computation, cross references and rule driven, now embedded in tables and formulas, reduced computation disputes. Interest for late payment 1% per month under section 115 TE, now explicit formula in section 352(6), greater certainty. SSC in default provision, section 115 TF, now it is covered under section 352, simplified enforcement. Recovery mechanism, implicit and scattered, now express recovery provision, section 352 8 and 9, a stronger enforceability. Tax neutral mergers, section 11 to section 12 AC, inserted later, integrated with section 352, conditions harmonized. Other violation, loss of exemption, section 13, 10 and 11, now section 353, continuity and consolidation. Tax consequences of violation, income taxed at maximum marginal rate, same consequences retained, no policy dilution. So, in this part you will find more or less same has been retained, but for the cleaner and clear provisions. Now, part 6, approval for the purpose of deduction under section 133 1B2, now section 354. Section 354 does not alter donor deduction policy, but fully integrates the 80G approval regime into registered NPO framework. It removes legacy transitional complexity and embeds approval, monitoring and cancellation within a single statutory architecture. A statutory location, earlier section 80G in chapter 6A, now in section 354 under special provision the registered NPO, shift from deduction chapter to NPO life cycle framework. Nature of benefit, deduction to donor for eligible donation, same donor side deductions, policy continuity. Eligible institution, funds, institution established in India for charitable purposes and meeting section 80G 5 conditions, now only registered NPOs satisfying section 354 condition, alignment with the unified NPO regime. Approval framework, 80G 5 plus multiple provisos. Now section 354 provides a complete self-contained code, cleaner drafting. Application process, online application introduced later, transitional reapproval mandated in 2021, now online application fully embedded, digital first design. Processing timeline, largely rule based and notification driven, now time bound processing written into the act, certainty for NPOs. Provisional approval introduced via amendment post 2020, now expressly codified in section 354, a structural clarity. Condition for approval: charitable purpose, genuine activities, compliance, same conditions consolidated, harmonization. Monitoring of cancellation through section 80G 5, 3 and 6 and allied provisions, now linked to section 351 to 353, integrated enforcement. Effect of non-compliance: loss of donor direction eligibility, same consequences, no dilution. So, this is the part 6 of the NGO provisions. Now, come to part 7, interpretation and definition, section 355. Section 355 completes the shift from a case law driven exemption regime to a definition led rule based NPO code. It eliminates redundant concepts and introduces disciplined accumulation through clearly defined terms. Dedicated interpretation section. No single consolidated interpretation section for NPO regime, meaning scattered. Now, section 355 provides a dedicated definition clause for the entire NPO framework. So, it is a major structural improvement. It reduces litigation and disputes. A scope of definition: limited and indirect definition is, for example, anonymous donation in 115 BBC, related person via section 13. Now, comprehensive definition including anonymous donations, approval cancellation, donation, commercial activity, registration, registered NPO, related person, relative, residual income, a specified asset, a specified person, substantial interest and value. So, now absolutely there is no confusion about these terms. So, the court also will not venture into reinterpreting these provisions, because there is a complete clarity provided in it. Now, we can sum up. Charitable purpose. Section 223 of 2000 Act defines charitable purpose. Proviso clarifying advancement of any other object general public utility removed. Section 215, 1961. This is a very major departure from that act.
So,
Stage-
only one thing, since if the proviso has been removed and it has been brought under, I think, section 340, that 20% rule. So, what would be the implication of this removing?
Tax will be charged only. You will not lose exemption.
Okay,
It is a major shift.
major shift.
It is a
yeah.
major shift. You cannot be categorized in non-charitable.
Okay,
You can, the registration will not be cancelled. The purpose is to collect tax. Purpose is not to destroy the institution.
correct.
So, you are a 100-year-old institution. You are carrying on certain activities. You are generating surplus because your costs are much less. You have don't have to pay the rent. You don't have to create new infrastructure. You have employees who are well versed in your work. So, your cost to input ratio is much less. So, you are generating surplus. That surplus is more than 20%. So, now more than 20% part will be taxed, but you will not lose exemption. You will continue to be a charitable institution.
Okay.
So, it is a great source of strength.
Which means, sir, all those non-profit organizations, suo moto also they can
Yes,
declare
exactly.
30% करके, हाँ.
Now, when the law defines, you can do it. No? You can do it in the return itself. In fact, that clarity has been brought for litigation free regime. You know, you have received anonymous donation. That anonymous donation has to be taxed at the rate of 30%. You show it in the return or not?
Yes.
You do that. Likewise, all those areas where exemption has not been granted to you, but you continue to enjoy charitable status, you have to suffer tax on that.
Right.
So, this complete clarity of purpose with which the law has been drafted. Your question is very apt, and therefore, it clarifies that part of it. Now, a statutory design, entire NPO law consolidated into a single dedicated chapter 17b. Everything is in 17b. Drafting style, I have just read out to you the 7 steps, and all these steps are one by one, are codified in the section. You do not have to go anywhere. It is a complete code in itself. Drafting style, shift from proviso heavy amendment to modular definition led code. Registration framework, multiple parallel regime replaced by one unified registration system. Person eligible for application of registration as NPO is defined in section 332 1 and 2. Now, this is for the first time. Who can apply for registration as a person under the law has been defined with clarity. So, therefore, that is a truly revolutionary. Following persons covered in 332/2025, Investor Protection Fund, section 1023EA and 1023EC and 1023ED of 1961. Now, these things, although the part of the schedule, but from the schedule, these has been clearly brought in the section itself, so that they have to apply. Body or authority or board of trust or commission established or constituted by or under the central or state act or provisional act of CG/SG under section 1046 of 1961 act. Body or authority or board of trust or commission not being a company established or constituted by or under the central or state act or provisional act and notified by this, if they carry one or more charitable purposes referred to in section 223 or one or more public and religious purposes, they can apply for registration and they can qualify for deduction accordingly. Validity of registration, mandatory time bound validity for all registrations. Renewal, a statutory embedded renewal cycle. Then monitoring and model, compliance review linked to renewal and violations, preventive and oversight. Regime switching, one time statutory choice of tax regime introduced. Donor approval, section 80G regime fully integrated into NPO chapter, section 354. Charging of income, first explicit charging section for NPO in section 334. Income classification, a statutory segregation to regular income and specified income. Activity income, expressly defined for the first time. A specified income, all abuse related income consolidated in one provision, section 337. Anonymous donation, taxation only beyond prescribed threshold. Deemed accumulation, new concept of deemed accumulation introduced. Investment discipline, mandatory investment of deemed accumulation is prescribed modes. Commercial activity code, dedicated sections governing commercial activities, section 344 to 346. Deeming fixed and removed, excess business income no longer deemed non-charitable. Non-GPU NPO, absolute statutory bar on commercial activities. GPO NPOs, breach leads to taxation of excess, not loss of charitable status. Compliance structure, separate compliance chapter for books, audit, reporting and investment. Then investment regime, section based list replaced by schedule driven framework. Violation concept, specified violation exhaustively defined. Exit tax, accredited income provision rewritten into single consolidated section. Computation method, formula based exit tax computation embedded in a statute. Transitional burden, one time reapproval regime 2021 eliminated. Definition, dedicated definition introduced, section 355. So, you see, very scientifically organized and very explicitly defined, non-litigation oriented provisions to the most complicated part of the Income Tax Act. which has led to huge number of litigation, can be avoided with the new regime under 2025 Act. So, I think the changes are welcome changes.
Very welcome.
Yes. As compared to so many changes, so many new thought process, so many beneficial and disciplinary provisions brought in this NGO provisions, as far as the appellate part is concerned, more or less all the provisions of the erstwhile Income Tax Act 1961 has been retained. Because these if you have the note given by
Yeah,
me.
we all have to know.
Now, this chapter 18 of 2025 Act reorganizes and modernizes the entire appellate and dispute resolution ecosystem of the Indian Income Tax Act law. It integrates appeals, revision, advance ruling and dispute resolution into one harmonized chapter. This is in contrast to 1961 Act, where such provisions were scattered across chapter 20, 14A and chapter 19B. Some of had become dead because of the removal of the enclosure of the settlement commission, that was chapter 19B, and there were other provisions which had also become obsolete. So, now the core objective of reform, a structural modernization, consolidates dispersed provision from 1961 law into single modular chapter with clearer sequencing and unified drafting. Technological integration expressly enables faceless and system driven process for appeals, revision and ruling to ensure transparency and efficiency. Although in the new act this faceless has nowhere been mentioned, think this will come through notification. So, reduction of litigation and backlogs, expands jurisdiction of joint commissioner appeals, strengthens tribunal functioning and introduces flexible dispute resolution pathways, greater clarity and administrative flexibility, removes overlap, clearly defines powers of authorities and authorizes CBDT to classify cases for a special and faceless handling. Essence of reform: the hierarchy of appellate bodies remain intact, that is JCIT appeal, CIT appeal, ITAT, High Court and Supreme Court. The principle of natural justice and fair hearing remains unchanged. The framework is digitally compatible, globally aligned. It is far easier to navigate than the 1961 law. Comparative mapping of appellate and dispute resolution provisions, Income Tax Act 1961 vis-a-vis the Income Tax Act 2025, chapter 18. Appeal initiation. 246, 246A, 246 is JCIT appeal, 246 is CIT appeal, to 356 and 357 consolidated initiation provisions. Unified structure, clearer categorization and digital ready framework. Appealable orders before JCIT appeal, 143(1), 200A, 206(CB), 143(3), 144, 147, 200A, 206(CB) penalty orders under chapter 21, 154 and 155. Now, under the Income Tax Act 2025, 271, 399(1), 270(10), 271, 279, 398 penalty order under chapter 21, 287 and 288. So, the section renumbered a structural update. Then appealable order before the CIT appeal. Now, CIT appeal can hear 143(1), 200A, 143(3), 144, 147, 153A, 163, 154, 155, 221 and 271 series, that is under the 1961 Act. Under the new Act, 271, 399(1), 270(10), 279, 283, 306, 287, 288, chapter 21, 412 and 298. Renumbered and aligned to new assessment framework, because the CIT appeal can handle cases which are approved by the JCIT and the additional commissioners, but cannot be by the JCIT. So, therefore, they are in the category which is not with the JCIT, but with the CIT appeal. Forms and limitation. Section 245 multiple provisos and scattered timelines. Section 358 harmonized self-contained digital filing enabled consolidated procedure, fewer cross references. Procedure and appeal. Section 250 in person pre-faceless system. Section 359 faceless system based streamlined technology driven simplification and of subsection. Powers of appellate authority. Section 251 fragmented after repeated amendments. Now section 360 clean consolidated powers, substantive continuity but clearer drafting. ITAT constitution and governance, section 252. Section 361 modernized structure and qualification, transparent appointment norms aligned with tribunal reforms. Appeal to ITAT, section 253, now 362, reorganized for consistency, digital compatibility, recast list of the appealable orders. Order of the ITAT, section 254, now 363, clarified rectification and procedural framework, better integrated with digital timelines and stay rules. Procedure of ITAT, section 255, now section 364, updated for system based functioning. New Indian criminal codes BNS and BNSS replace IPC and the CRPC references. Appeal to High Court, section 260A, now section 365, streamlined wordings, explicit effect giving requirement to AO, simpler structure. High Court bench strength 260B, now section 360, no change. Appeal to Supreme Court 261, now 367, alignment with updated procedural law, modernized text. Hearing before Supreme Court 262, 368, harmonized with CPC provision and simplified. Tax payable despite appeal, same as before. Execution of Supreme Court cost, section 266, 370, cleaner wording, structure integrated within appellate chapter. Amendment of assessment after appeal 267, now 371, consistent codification within unified chapter 18. Expulsion of time for obtaining copy 268, 372, digital friendly simplification of limitation computation, procedural expulsion rules retained, time to obtain copy excluded. Now appeal by the tax authorities, section 268A, now section 373, consolidated department appeal management uniform application. Interpretation of High Court, section 269, 374, modernized and centralized definition. Identical question pending, earlier section 158A, now section 375, refined wording, SLP pending situations expressly integrated. Identical question pending 158AB, now 376, streamlined, hierarchy based deferral mechanism, collegium structure retained. Revision prejudicial to revenue 263, 377, new 60 days minimum balance rule, faceless revision compatible. Now age against 2 years, 60 days has been replaced. Revision in favor of SSC 264 and 378, simplified language, updated cross references, new 60 days safeguard brought. Dispute resolution committee 245 MA, now 379, embedded within the unified appellate code, conditions moved to rules, a scheme making language slightly restructured. Definition of advanced ruling 245N, now 380, consolidated interpretation section, modernized definition to advanced ruling, applicant, board, etc., chairman, vice chairman, definition removed, cross references updated. Board for advanced ruling 245 OB, now 381, modernized constitution removal, chair, vice chairman, definition. Then vacancies not to invalidate 245P, 382, same principle. Application for advanced ruling 245Q, now 383, simplify the structure, fee language change to age prescribed, ITAT versus explicit fee wording in 1961. The procedure for application 245R, now 384, streamlined 6-month ruling process, updated cross references. Appellate authority not to proceed 245RR, 385, jurisdictional bar retained with modernizing wording. Ruling void in certain cases, 245T, now 386, same fraud misrepresentation standard, clear expression. Power of advance ruling authority 245U, now 387, power retained but IPC, CRPC references replaced with BNS and BNSS. Procedure of advance ruling board 245B, now 388, clean drafting, system friendly procedure regulation. Appeal against ruling 245W, now 389, direct high court appeal retained, the scheme making powers removed. Key takeaways: organization. Provisions under the 1961 Act scattered across multiple chapters, inconsistent structure, now fully consolidated in one chapter with uniform drafting. Technology, mostly manual processes, faceless scheme added, piecemeal letter, now faceless system driven into digital compatibility built into law. Appellate bodies, CIT appeal, ITAT, High Court and Supreme Court, the same plus strengthens JCIT appeal. Dispute resolution, DRP, AAR, DRC under different chapters, now all consolidated in the unified section 379 to 389. Objective, reactive amendment over decades, now modern, streamlined, clarity focused dispute management system. Now, in this only one thing which is of importance, which we need to know. Recently the Supreme Court was seized with the new amendment which was made in section 352 by Government of India, whereupon the rules for appointing the members in the ITAT and the vice president, the president was changed, pursuant to which a person below 50 years of age could not apply for the membership of the tribunal. The Secretary Revenue and Secretary Law both were to be the members of the select committee. The period of the membership was 4 years with a right for renewal. Retired persons both from the revenue department and from the judiciary were permitted to be the members. Now, the Supreme Court in the case of Chennai Tax Bar Association's case have reviewed, and this 2021 rules which was made for the appointment of the IT tribunal members was analyzed and reviewed. They found that in 2010, 2014, 2016 and earlier in 2020, the Supreme Court had not upheld the similar changes which were brought by the central government. So, therefore, they have ruled against that. They have said that same rule which is applicable for a lawyer to become a member of the High Court will apply for the membership of the tribunal also. Say a lawyer with a 10 years of practice can apply to be a member. Likewise, later on they have passed another order where they have permitted the chartered accountants of the 10 years of practice who can apply, and the age of 50 years thereafter has been removed. So, the 10 years experience has become that, and then they have said that only one secretary law can be the part of the selection committee. So, therefore, the revenue secretary who is in charge of the Department of Revenue, against whom most of the appeals are filed in these tribunals, cannot be the member of that. So, therefore, the Chief Justice has been given the power to constitute the selection committee, wherein only secretary law will be one of the members, and then this 4 years period has been converted into 5 years period. So, these changes are welcome changes, will bring more independence to the ITAT and will strengthen the institution, and the justice delivery system will be better placed, because in the whole system of the appeal and adjudication, It is the revenue authorities who makes my assessment only when they become senior. They occupy the post of the CIT appeal or the PCIT, and from their orders only the matter goes to the tribunal. If the retired chief commissioners start becoming the accountant member and the person from the district judges start becoming the tribunal judicial members, then on both the counts the SSCs will be at loss, because those who will be coming from the district judiciary will be less equipped with the Income Tax Act. So, they will take time to learn, and 4 years will be a too small a period for them to become an effective member. And the chief commissioners normally have a pro-revenue bias. So, in that event the SSCs will actually have a very difficult time. So, this judgment of the Supreme Court is a welcome judgment, and hopefully in the budget which will come, the Honorable Finance Minister will effect necessary changes in the appointment rules of the members. So, with this I think we are up for the both the chapters for today. Sometimes in these sort of deliberations the proceedings becomes little boring, but all of you had the written text also before you. So, my words were all part of your written text. So, these are not lost, and I cannot speak in respect of a new law ex tempo, because then I will be missing out the right word and the right effect of these amendments. So, therefore, even if it is little boring, you have to bear with me. Thank you for bearing with me and being part of this discussion.
No, it was really value added, sir, and this note will stay with us,
Yes.
for a long time
Yes.
to understand the act. In case of any participants online, here, offline, any questions?
Sir, as we are moving to the tax year from assessment year, if any notice comes for reopen cases, 148 cases and 149 cases, it will be for tax year, or it would be continue to be the assessment year or previous
Assessment year, because the tax year concept will start from assessment year, from the tax year 26-27. Prior to that, all are assessment year based. So, though reopening will also be assessment year based,
But
So-
we will be receiving the notices under the new
under the new, under the old law only, because saving clause clearly says so. Any proceeding in relation to the income tax return which you have filed up to 31/3/2026 will be assessment year based, and it shall be assessment year based, it shall be under the old law, and all proceedings which are pending with the various forum shall continue under the old law. There are the 6 saving clauses in the repealed law, and these 6-7 clauses are contained in section 536. If you go through that 536, those 6 clauses will guide you fully as to where the old law will apply, where the new law will apply. New law for almost 2 more years will have no application except in your filing of return which will be due to be filed in 2027 post completion of the tax year March 2027. Since the writing of books of accounts is always had the accounting year base, so there is no substantive change in that. Only in respect of the NGOs, you have to follow a different concept, because there are lots of changes in the NGO, but as regards business entities and other entities are concerned, they follow the same system of account, and therefore there will not be any change. So, only change will come when you file the first return after almost 2 years, until that time only Income Tax Act 1961 will apply.
How, sir, for NGO, only when there is a business income also, commercial income also,
Yes.
then there will be a change. You have to maintain different books of account.
Yes.
Otherwise, the same will continue.
No,
How?
you see, now you have got chapter driven NGO. In that chapter driven NGO, commercial income has been defined.
Yes.
So, you have to, you may have to maintain a separate books of account
Yeah.
where commercial income is being brought in. They are specified, they have been categorized as specified income. So, a specified income will be taxed. So, you know about it. There will be activity driven receipts. These activity driven receipts will qualify for exemption if you have spent 85% of your gross receipt in either capital expenditure or in revenue expenditure. So, that will continue the same way, but now there used to be controversy as to what can be taxed. That controversy has now been removed. So, you can maintain separate set of books of account for those activities which will be taxed.
Right.
So, that way NGO will have a complete clarity that income about 20% from this activity will be brought to tax. So, you can categorize so much 20%, yeah 80%, you took it separately to that account. Therefore, you can compute up ultimately how much tax will be there, how much advance tax you should pay, how much all these things you can do. So, that is only this NGO chapter
Right.
which makes you follow the new law. Otherwise, all other income will conform to the same income, nothing
Right.
different.
Any other question? Anybody here online? একটা mic একটু দিন।
Now the rates are specified in the act itself. Earlier it was in acts and finance act also. So how this will now is in the finance act only for the amendments it will be relevant, or
See, whenever a new law is brought, a confidence is created. That is the end of the controversy. But you see, every year a finance bill is presented in the parliament. I do not know what the finance minister this time will bring in the finance bill. Because see, when the constitution was enacted unanimously, even before first general election took place, in 1951, the cabinet approved an amendment in the constitution where on all fundamental rights under article 19, restrictions were placed. Rights, duties were also defined. So, the same constituent assembly which enacted which adopted the constitution, amended the constitution on the fundamental right chapter, on the most important article 19 of the constitution. So, therefore, whatever they may say, we never know. They have got the strength of the legislature, and in a democracy it is the legislature which empowers them to adopt a legislation. So, they can amend the rates, they can change the law. So, and every time when the law is changed, new act is brought, the same explanations are given that over a period of time the changes had become so such that it had become very difficult to follow. Yes, although true, this time the legislation has been drafted very scientifically, everything being chapter wise enumerated. But let us see, we cannot predict the future.
Also in the charging section, I think section 4 here also,
Yes.
they have mentioned the same thing, that the rates will be decided as
Yes.
per a central act.
Correct.
So same, I think, Finance Act will lay down the rate. But sir, in addition to his question, this 30% which on this accredited income, that will remain 30. No additional education cess, surcharge, etc.
No, it's a tax. Where do you say surcharge will not be given? Has they said that surcharge will not be charged? They can impose surcharge by central law, nothing. Accredited income is fine. That the tax rate is 30% only.
But then sir, they have said no, surcharge is also a tax.
That is true. But where do they say it is a tax there? But when it comes to allowing you reduction, they say it is tax also. Because
Yeah.
the surcharge was claimed as a deduction, na?
Then they bought the amendment.
Yes.
कौन सा section है?
Accredited income section 358 देखो तो बोला हाँ चार्ट लाओ accredited income लाओ नहीं ओवर टैक्स accredited income कम यार SAC in default provisions, section 115 TA, covered by section 352. 352 follow. One by TD, come to section 352. 352, come to section 352. Every specified person shall, in addition to income tax chargeable in respect of his total income, be liable to pay additional income tax on accredited income at the maximum marginal rate in any of the cases specified in column B1 and 2 of the table to subsection 4. The accredited income referred to in subsection 1 shall be computed using the following formula: A is equal to B minus C, where accredited income is equal B is equal to aggregate fair market value of the total asset of the specified percentage on the date specified in column C of the table in subsection 4, computed in accordance with such method evaluation may prescribed total liability बात दे करके subsection 4 के अनुसार से specified person and the principal officer or trustee of such a specified person shall be allowed to tax on the accredited income to the credit of central government within 14 days from the due date specified in the column D of table below. A, B, registration granted, order of cancellation, 4, date of adoption, last date for application of registration, date on which date of the merger such and dissolution. The payment of tax on the accredited income by the specified maximum marginal rate ही कहा उन्होंने?
एक जगह 30% बोला है.
That is the maximum marginal rate ना?
नहीं, they have mentioned in the act 30%. एक बार उसमें देखिए. Section was it?
30% तो इनकम नॉर्मल इनकम 11 वाले में बोला है. लाओ ये रही है सेक्शन 334 इनकम टैक्स पेबल रजिस्टर्ड नॉन प्रॉफिट ऑर्गेनाइजेशन ऑन टोटल इनकम फॉर एनी टैक्स ईयर shall be aggregate of the amount calculated at the 30% of the specified income for such tax year at the rate applicable on taxable regular income and any residual income for such tax year under other provisions of this act. तो 30% ठीक है, स्पेसिफाइड इनकम के ऊपर में है, और एंड एट द रेट एप्लीकेबल ऑन द टैक्सेबल रेगुलर इनकम एंड एनी रिसीडुअल इनकम फॉर सच टैक्स ईयर अंडर द प्रोविजन ऑफ दिस एक्ट. तो 30% तो एब्सोल्यूट नहीं किया, एंड वर्ड है वो थोड़े.
That is regular income.
हाँ ठीक है, एंड एट द रेट ऑफ एप्लीकेबल ऑन टैक्सेबल रेगुलर इनकम. सो 30% इसमें दे दिया, प्लस वो स्पेसिफाइड रेट दे दिया. द प्रोविजन चैप्टर शैल अप्लाई irrespective of anything to the country contained in any other provision of this act So 30% is the rate, that is the highest marginal rate only. 30% is the highest marginal, 115BB is not the highest marginal rate. It is for a specific type of income, which are falling under section 68, section 69, 69A, 69B, C and D. So they are not the regular income. They are not, they are the income from other sources. They are not falling under any of the categories of income like salary, house property, or business income, or capital gain, or other sources. These are the modes of earning income. Those income which doesn't have any source or clarity, they only fall under for 115BB. Highest marginality 30% only.
So no education cess and surcharge on this, sir.
No, अभी तो इसमें नहीं बोल रहा है.
But
देखिए,
maybe they'll bring it out in the
maybe
finance. Act.
because under the finance bill only that will be clear.
Sir, one more question. I
Yes.
mean, this is more of a theory and also practically what will happen in your view. Like in this 536, this repeal and saving in this act, vis-a-vis 297 of the current act, sir, which has repeal and saving of 1922 act. I found a difference. In that act, sir, they say the any assessment after 1962, the tax will be charged as per the 1922 act, but the penalty will be charged as per 1962 act. I think 297G, that is. But in this act, they have made a departure under 536. They say penalty as well as tax, both will be charged in the new act. So do you think, sir, now this two orders, penalty order, tax order, different, quantum order different, that will change. They will have one order for both, penalty as well as quantum.
No. I don't think that penalty and tax can be charged together. Penalty is for violations, and violations are established at a level. Assessment is not complete till appellate jurisdiction is exhausted. Now section 275 debars imposition of penalty if your matter is in appeal or if your matter is in tribunal. Only after it is exhausted, because penalties are basically finding or based on the factual finding in assessment, and High Court will be seized only with the question of law. Where the question of law is involved, penalty will not be there, because that is interpretational. So you may have one view, I may have another view. The final view may be settled up to the Supreme Court. So you cannot be charged to penalty for following one view, and you are not agreeing with the departmental view. So you will fall under section 278(6). So then penalty will not be charged. But assessments on fact is not complete, because the last fact finding body is ITAT. So therefore you cannot compute penalty in assessment, because it has not become assessment, final assessment, till tribunal takes a final decision on the addition which you are proposing. So there cannot be a single order imposing both tax and penalty. So the same thing will continue, which has been continuing now also.
Okay. Any other question before we can wind up for the day? Online participants, anything?
Yes, sir. This is Sumit Gupta from Excite.
Yes.
Yes, sir. My question is regarding that whether that TP assessment and that center circle assessment investigation, it will be faceless or face to face.
You see, so far the TP assessments are not faceless, but they want to go for the faceless regime. I do not find any reason why a TP assessment will not be faceless. So it will depend upon the notification which will come post the operation of this law or just prior to the operation of this law, whether the TP can also be faceless.
That will
And
depend
in
upon
the-
the notification.
Yes.
And sir, what about the investigations, Central Circle investigations?
No, they are not, investigation is the result where the investigation is done through the process of search. That search leads to collection of evidences against you. Those evidences are in the form of either your books of accounts or assets or documents, and some digital documents also, emails, etc., etc. This requires a participation of the SSE or his counsel face to face. So, I do not think the search assessments in Central Circle will become faceless. They shall continue to be person to person presentation. So far I understand, although recently when in 2021 settlement commission was abolished, the settlement commission mostly dealt with the search cases, and the applications which were filed by the SSE were pending in large numbers. They made it virtual, not faceless, and the entire proceeding was conducted virtually. In that face to face, person to person contact was not there, but virtual contact was there. So, in that virtual contact, the seized documents were explained, and ultimately all the cases were settled amicably. So, I think even in case of Central, if faceless is not introduced, which is not practicable, this virtual system may be introduced.
Thank you, sir.
Yes. Yes.
Can you read? Yeah. No, it is not visible here.
We have one question from Mr. Shantan Bhattacharya, APJ Group.
Yes.
Can you please let us know whether business income of an educational charitable trust utilized entirely for charitable purposes qualifies for exemption under Section 11(4)(a) Income Tax Act will remain same, or as per new section of 345 it will change?
No change has been brought about as far as the charging to tax is concerned. Only condition which was there earlier also in 11(4)(a), that if that business is being carried on to meet the object of the institution, then the profit emanating therefrom, if applied for charitable purposes, then shall be allowed as deduction. As for example, you are a hospital, a charitable institution, you have got a medicine shop down below. To meet the requirement of medicine for the patients who come for treatment in the hospital, then for the better and proper functioning of the hospital and requirement of the patient, such a functioning of a medicine shop down below the hospital is the basic requirement. If the profit emanating out of such business is applied for charitable purposes in entirety, that shall be allowed a deduction, although it is a commercial profit. If not applied, it will be charged to tax at the rate of 30%.
Mr. Bhattacharya, you may switch on the video and
Hello, sir.
Yes.
Sir, it is an incidental income, right, sir?
Yes. Incidental income, right.
Right.
Incidental to carrying on the charitable activity as a hospital, which is a non-profit undertaking of the NGO.
Correct, sir. Thank you, sir. Thank you.
Thank you.
any more questions from the online participants?
Okay, I think, yeah,
Yes.
one
Sir, just I have got one confusion regarding that
switch on कर लीजिए आदित्य जी.
536.
536M. There it is
Come
written
536.
that ki long-term capital asset, long-term capital loss and short-term capital loss.
Which clause?
536N.
N.
Yeah.
L. Come. In any amount of credit in respect of tax paid allowed to be carried forward
No, sir. Any amount of loss under the head capital gains.
to which clause?
N.
N, yes. Any amount of loss under the head capital gain, whether related to a long-term capital asset or short-term capital asset, referred to in section 74 of the repealed Income Tax Act, brought forward from the tax year beginning from the first day of April 2026, had the Income Tax Act 1961 not been repealed, shall be carried forward and set off in accordance with the manner prescribed in the repealed Income Tax Act against the income under that capital gain computed under this act for any tax year beginning on or after first day of April 2026 up to 8th financial year immediately succeeding the financial year in which such loss was first computed under the repealed Income Tax Act. What is the confusion?
I just whether short-term capital loss can also be adjusted with long-term capital gains.
No. The mode of computation and mode of set off continues to be the same. No, because this is a saving, repeal and saving provision. This is not enacting new law. This is not giving you new authority and new power. It is only saying as per the provisions contained in 1961 Act, it shall be set off against the future income of long term and short term capital gain in accordance with law. So, no new power has been vested.
And ends talks about only carry forward,
Carry forward, that is all. Set
not
off.
set off. Set off is
Set
ruled
off to
by
will be
a-
on the income, available income. नहीं ठीक है, वो ऑटोमेटिक है, ऑटोमेटिक है.
set off कहाँ?
नहीं,
Okay,
carry-
and set off.
नहीं, carry-
Okay,
carry
in
forward का
accord-
मतलब ये सेट ऑफ है.
set off in accordance with the manner provided
Yes,
in the repealed income tax. Act.
Yes, yes.
Same manner.
Absolutely same. Nothing. Oh, these saving clauses only saves the law as it existed prior to the enactment of the new law. It neither creates new rights nor exercises new liability on you.
Okay, so I think we can wind up. So thank you, sir, for dealing with such a intriguing topic on NPOs and appeals. Thank you very much
My
from
pleasure.
our Chamber of Commerce for your time.
So sweet of you.
We have a small memento for you. Thank you, sir. Thank you, sir.